Namaskar. A very warm welcome to all of you in the second session of Moot Court Workshop series, Ace the Art of Mooting, Analyzing the Moot Problem. Now, I invite our esteemed speaker, Advocate Animesh ji, to take over this session and deliberate upon the topic. Thank you. Animesh ji.
Thank you, Alok ma'am. Thank you everyone for joining this Monday evening. Let's hope we are going to have an engaging session, and let's have a format where let's have a conversation, which is what I'm going to speak for 30 minutes. And then for 15 minutes, I'll be very happy to take individual questions, because moot court is unique to everyone. Everybody has their own method of dealing with some of these aspects. And therefore, there is no single formula to things. And it really helps to engage with people as to what their methodology of dealing with these aspects are, and what can be done in that given situation to better it or change it. So it will be very critical that I get a lot of questions and feedback from the participants, so that I'm able to look into what they are looking for and be able to identify and correct some of those aspects. So we can break it into a session of half an hour, 15 minutes, half an hour, 15 minutes. Perhaps since we're already 5-7 minutes plus, we'll adjust that 5-7 minutes somewhere so that we finish sharp at 8:30. Right. Now, today's session is on preparing a moot. And this is very important because this is how you start. And very similar to the English phrase that you cannot judge a book by its cover, how we are going to fare in a moot court cannot be judged by our preparation in the beginning. It certainly cannot be fully judged by reading the problem. And why I begin with this is because students often have this query as to which moot court should they choose for. And I was very glad to know that this is an open moot court society, which is giving an opportunity to anyone and everyone to pick up whatever moot you want to. And different law schools have different systems, but the more closed the moot court society is, the choice to choose a moot becomes more restricted. So I'm quite excited with an open moot court society, and I don't know how selections are made, but I presume in an open moot court society, it would be like a challenger. That when a moot problem would come in, students can give in their name and there will be an internal competition. And whoever succeeds perhaps gets to participate in that moot court, rather than having an internal moot where you have a ranking and people choose their moots accordingly. Therefore, it's very important not to judge a moot by the problem. And sometimes students make a very firm view that I'm going to do only public international law moots, or I'm going to do criminal moots, I will only do trial moots, or I will do moots on taxation. And sometimes I have seen that does not augur well for students. And I'll tell you why. It is very, by the time you're in your final year and you're looking for a placement, everybody looks for some kind of specialization. There's some law papers which you tend to like more and you understand more, you have a better grasp on it. And therefore you're very focused as to where you want to go. But if you are going to keep that focus on your moot court as well, say for example, if you want to aspire to be a tax lawyer and you only want to go for taxation moots, the flip side to that is that you become a very dull boy. Why? Because you have very little idea of analyzing any other law. And to be able to excel in any one specialization, it is very important that you have some kind of background in another legal subject. And as lawyers, we face that all the time. I think as we all start aging in the profession, we become very aware of the fact that we know far little. I mean, that's what I feel. Every year that I add to the bar, I think I know far little as every year grows on. And therefore, you sort of become very limited to some specific areas of practice. And that is not what you're supposed to do while you're still in law school. In law school, the idea is to explore different subjects, to know more. And therefore, never judge a moot by the moot problem that comes to you. Never judge it by a subject. Sometimes going for a moot which is out of your comfort zone can teach you far many things than doing a moot which is in your comfort zone. Now, when I pick up a moot problem after we've made a selection, Usually there is a time gap of any time between 15 days to about 4 to 5 months to prepare a moot court, depending on which moot court you are going for. And there has to be a strategy for this time management. Sometimes when you've got 4 months, 5 months, you don't tend to put in regular amount of work over these 4-5 months. And a lot of the work is concentrated in different patches of time, which is also sometimes it reflects in your preparation, in your presentation on the final day. So these are some of the things which we will discuss upfront. What do we do when we get a moot court problem in our hand? It is very important that you read the problem from the first word to the last. And often while you are reading it, you find it very different. Sometimes the subject matter is something which you've not read on. Sometimes, say, you are having a subject where the subject matter is about religious persecution in a particular country. You've never really had the chance of looking at religious persecution laws. Maybe you've never had the chance of looking into a news piece which is about religious persecution. Sometimes the moot courts involve technical aspects. Say, if you are going for an IPR moot, you may have issues of patent specifications. These are some aspects which you may not be very conversant with on the first read of the problem. So our inherent tendency is to not read the moot problem cover to cover. We either slow down, we read it line by line, or we start Googling every term that we don't understand, or we start making certain points, certain notes. That impacts you terribly when you're finally doing the moot. It is very important that you know the moot problem at the back of your hand. That is fundamental. If you don't know the moot problem at the back of your hand, there is no leniency that any court, any score sheet is going to afford to you. So it's very important to know the score sheet at the back of your hand, for which it is very important that you have a scheme to read the moot court problem. Now, what's the scheme to read the moot court problem? As I said, first, you must read the problem cover to cover, even if you're registering very little. Have a basic sense of what it is. If you're doing a public international moot, see how many countries are involved. If you're doing a criminal moot, tentatively see how many crimes are involved. If you're doing a constitutional law moot, see what kind of constitutional problems are involved. You have a first overview of the moot problem, which certainly goes by the phrase, don't judge the book by its cover, don't judge the moot by the first read of the problem. But it is very important for you to get a first sense of what the problem is about. Don't stop for anything. Read it cover to cover. I am emphasizing this 4-5 times because it is very important. Once you've gone through the moot court problem, you have a sense of what the problem is about. And let me tell you, to some aspects, that sense will be a final sense. And to some aspects, your view on the problem will change many times over. Because the whole concept of moot court problems is that the drafter of the problem has tried to incorporate different facts, which makes it arguable from both sides, which makes it arguable from every point. And therefore, there is a lot of revision which we do as a drafter of a problem. And I'm sure a lot of you will graduate to draft moot court problems yourself. And you will realize it's a lot of fun to create moot court problems. But again, it's very difficult because you are creating, if I could use the analogy, an onion. Every time somebody reads, it's like peeling off one skin and finding something else. And if that mystery is not there in the facts, then it will not be arguable for both sides and it will not be a lot of fun. So it's very important that when you start reading the problem the second time or the third time or the fourth time, you start making some kind of understanding as to how you'll categorize these facts. But don't write it still. Don't start making notes. You must give a moot court problem at least 2 to 3 reads before you even think about making notes on the problem. Once you have an idea of the problem, and if you already have a selected team going to a moot court, or you have a bunch of friends who are commonly preparing for a moot court problem, it's very important to have a conversation about these facts. Just a simple discussion. Nothing on the law. This is what is on the facts. Oh, this is a murder trial. This must have happened. Okay, why was he driving the car like this? Was he driving at a particular speed? Or is that fact present? Have a conversation about it. A lot comes up when you converse about the problem from different minds, because different people look at it from different ways. After you've done this initial exercise, you must make a system to note a problem. And I suggest that you must take a separate notebook or a diary, which must be only to record details of the moot court problem. Now, this may seem, very specific. Everybody has their own ways of note making. But it is very important that you must have a separate notebook where you will record what you understand of the moot court problem. And keep a thin book, but I suggest that you do not record anything else. Do not try to save paper by trying to record something else from the back of that notebook. That one notebook must only be for your moot problem. And why I say this is, imagine you are arguing the moot court on the day of the competition. And it's a 10-step environment. You are on the podium, you are presenting a point. There are 3 judges, maybe one of whom is completely sleeping and is not looking at you. One is completely aggressive and going at you, hammer and tongs. With so much happening at this stage, the human mind tends to trick you by not giving the right input. You would have read that part of the moot problem, you would know it, but in the heat of the situation, it doesn't come to you. And therefore, your mind should know where that fact is. And I will deal with how you mark a problem. But what you must do on a notebook is that you start recording certain set of facts at certain places and flag that notebook before you go for the competition. So say, for example, issues, there are 4 issues in a moot court problem, and questions that are coming to you are from issue 2. You know that the pink flag on your notebook deals with facts related to issue 2. You flip it open, it's right there. Not only the fact is there, but also maybe what you think of the fact, or maybe what you thought of the fact, but really wasn't there. And there is no, it's one of those aspects which you as a moot court judge really enjoy. Pulling somebody's pants down on the facts. You tell a participant, and the participant gives you a particular fact, and then you say, oh, please tell me, where is it on the moot court problem? Or, they say, okay, please look at paragraph 4. Where is it? You've used this specific word. Where is this word on the moot court problem? And it can be very demoralizing and very, very discouraging when you look at the moot court problem in front of everybody and you say, oh no, I got the moot problem wrong. How could I get the moot problem wrong? I've done so much of work on this moot. I've read so many case laws, so many points. How could I make such a fundamental error? And that fundamental error costs you. It not only costs you because you made a specific mistake, it costs you because to the judge, it means here is a participant who is not even sure of basic facts. What else would he have done? I'm sure, the rest of his memorial and structure, it's not good enough. It's human tendency to make a view of a participant like that. Therefore, very important that you never slip up on facts. I said at the first session, it is almost impossible to make an error-free memorial, but you should never have an error on the facts of the problem. Now, therefore, am I suggesting that you must memorize a problem? And it can be very difficult to memorize a problem because not every problem is a couple of pages. If you are going for international arbitration moots, some of those problems could be 120 pages. If you are going for Jessup's, that problem could be 15 pages. If you're going for Stetson, that problem could be 40 odd pages. If you're going for Manfred, the problem could be just 3.5, 4 pages. But so much fact would be in those 3.5 pages that it is almost difficult to memorize something like that. And not all of us have a memory where we are able to register and memorize something by rote. And then the question, is it really important to memorize a moot court problem? Now, what I suggest to most participants, and this is what I've learned with experience, which works marvelously. When you get a moot court problem, please number every sentence or every line rather than a sentence. So if it's a problem of 4 pages, you have first page number 1, it'll be 1, 2, 3, 4, 5, 6. Like you have placitums in SECs where you've got A, B, C, D, E, F. Like that, you write down 1, 2, 3, 4, 5, 6, 7, 8 against every line on the problem. Why it helps is every time you read the problem, you will know your mind will automatically see that when you read a particular point, you'll see, oh, that's the 8th line. Oh, that's the 12th line. That sort of automatically creates memory. And therefore, when you're asked a fact, you know, oh, that is on the 3rd page, and that must be on 12th line. You say, your lordships could look at page 3, line 8. You win your judge like nothing else. If here is a participant who not only knows that there is a fact like this, but knows where is it, and it accurately tells me that this is the page number and this is the line number, not the paragraph number, the page number and the line number. Fantastic. You win the judge. You win the judge's confidence. The judge automatically feels this is the participant who's thoroughly prepared. Now, once you've done that exercise, and as you advance into discussions on issues, sub-issues, arguments, sub-arguments, you will see that there are certain connected facts which are spread all over the problem. But all of these facts connect to one legal argument or one sub-issue. Very important that in your notebook, you must have a separate page where you start noting it down. And when you note it down, write page 3, line 2. Why I say, sometimes when you are arguing a point, you would want to refer to facts which are at 2 to 3 different places in the problem. And therefore, your mind will automatically build memory. Oh, that particular point, yeah, there were three points on the facts. One was on page 1, one was on page 7, one was on page 9, and there also which pages it is there. That impact is incredible. I have, during my mooting days, I remember I used to do that with a lot of my problems. And it used to work like a charm. A judge asks you a fact, you say, your lordships, on the facts of the problem, there are 3 points which specifically say why this should be like this. 1, page 1, line 3, kindly have that. The judge often will, go to page 3, line 1, read that. Then you'll say page 7, line 2. Then you'll say page 10, line 3. And 9 times out of 10, the second and the third time, the judge believes you. He doesn't flip through his moot court problem to see that you're reading right or reading wrong. That builds trust. And once the judge knows that what you're saying is trustworthy, your subsequent points and subsequent arguments become far easier. You're grilled lesser. So very important to get the facts at the back of your mind. Read it to get a view of it. Don't read it to learn it. Once you've gotten a view of it, discuss it with your friends to get a variety view. Once you've gotten a variety view, start marking your problem. Read it as many times as you can before a moot court problem. And believe you me, even 10 minutes before the competition, if you will clear your mind and calmly read a moot court problem, often something new props up. So very important to deal with moot court problems like this. The second question is how to identify, read, and apply the applicable law. And this is very important at the initial stage. If you've already studied a subject, say you're going for a criminal law moot court problem and you've already studied IPC and CRPC, or if you're going for a constitutional problem and you've already had a background in constitutional law and administrative law, you would have some sense of what are the applicable laws. It could also be that you've never read that problem. Say the problem is on international criminal laws, and you've never really studied it as a paper. A lot of law schools will not even have it in their curriculum. You are maybe going for something very specific. The problem is on the Designs Act. It's maybe one of those papers that you don't study with as much detail as you will study the Copyright Act or the Trademark Act. And sometimes you will have a problem which deals with a law which you've not studied in your course curriculum. Your approach in both of these situations are different. But what you are going to do is fairly simple. It is very important to know that when you get a particular fact, whenever you get a memorial, almost 99.9% of the times, the drafter of the problem does not create it from his imagination. There is some reference that the drafter uses. So if you are going to do a Google search on what the problem is about, almost 9 times out of 10, you will get some kind of content to read. And I think it's an anathema in the sense that I'm sure when you are taught legal research, these days there is a specific emphasis to tell you that Google search is not the final port of call for lawyers. We cannot look up things on Google search and take it out from there and rely on that. But please understand, this is a beginning. This is for you to be able to identify what are the applicable laws. And sometimes a normal Google research can give you a very good idea of the kind of laws that are involved, the number of laws that are involved, and what laws that are involved. It gives you a starting point of where to read. The second way of analyzing is that you start reading applicable case laws. And when you start reading applicable case laws, it's very difficult to get the exact case law. Don't start doing exact case law research. Oh, this is my exact sub proposition. If any judgment would say something like that, oh, wonderful. My point is argued. It's settled. Don't do that. Start reading a little about the subject, a little about the law. And once you start reading different case laws, which are on very different facts, you will start seeing that maybe there is an interplay of different statutes, different rules, different points. Maybe some other case laws have been discussed. And you must have a separate notebook at the initial stages to just write down the number of statutes or the number of treaties or the number of rules, regulations, notifications, circulars, General Assembly resolutions, specific aspects of law. You must note it down at a particular place. And why is this important? When I was in law school and I was getting the same kind of training that I am in the position to be able to give to you, one advice that was given to me amongst the many good advices I got, and I'm very grateful for those advices. One advice that I got was slightly ambivalent. And that is, what in case I made a mistake? I say something wrong. Should I say I plead ignorance? And that has been something which I've thought over at different stages. When I was a mooter, when I was going as a moot court judge, as a young lawyer, when I started going for a moot court judge, when I had done substantial amount of moot court judging. There is nothing which takes points away from you than a judge not trusting you as a counsel. And that's true even if you're doing court practice. If you've lost the trust of the judge, even on something very insignificant, you have lost his trust. And therefore, it is very important to build trust. Like I spoke about moot court problems, there is something similar on applicable law. If a particular judge says, have you had the chance to look at that statute to examine this problem? And it could be something which could take you completely by surprise. You would have maybe not even heard of this statute, or you would have never thought in your remotest of imagination that such a statute applies. If you've done that exercise, you can immediately open the page and see that throughout your preparation time, what are the applicable laws that you've noted down? And if you've not noted down the statute which the judge is saying, and you say, I'm sorry, your lordships, I may not be aware of this law, but to my understanding, the submissions that I make, I do not require any help from this law, or this law doesn't apply. Or for these reasons, your lordships, it may seem that this law applies, but the law actually doesn't apply for these reasons. So to be able to have that clarity of argument on the final day, it is very important that on a separate page, you must keep noting down what are the applicable laws. And here, don't write down the sections or the treaty number, or the clause numbers. Just write down the law that applies. Don't tire yourself down with the details of what law applies. Once you have an idea of the applicable law, what do you do? For example, if some of you have gone for the Oxford Prize Moot or are planning to go for the Oxford Prize Moot, it's a very open-ended problem. And it allows you to read literature of many different jurisprudence, which means that even if you get 2.5 months to prepare for that moot court competition, it's impossible to get a grasp of that literature. It is difficult as it is to read a particular jurisdiction's laws and literature. It's impossible to read laws and literature of maybe the entire Commonwealth of Nations. So what do we do in such situations? We can't possibly read all of the law. And this is very important. One must be able to know that when you're reading law for a moot court, there are two types of law you read. One is that you read a law by understanding the subject itself, right from what the preamble says, what is the intent of this legislation, which legislation has it overruled, what was happening when this legislation did not come into effect, what are other applicable points of this legislation, what are other sections which are often quoted and cited. That's one aspect. The other are very specific aspects which are critical to your problem. Say, let us take an example of a statute which most of you would have read by now, would be the Contract Act. Say the problem is specifically on, say, frustration, force majeure. We've been having such a conversation about force majeure during the COVID times. Say the problem is specifically on force majeure. Should I be reading what are the definitions given in the Contract Act? Is it important for me to read the chapters on agency on the Contract Act? And this is where you must have a categorization. I must know the subject, which is including the preamble, the definition, other chapters. And one is specifically that section 55, 56 has to be seen, section 37 has to be seen. We will do a research only on these sections. Here, and I'll add on this a little later today, it's very important to have a team role. Not everybody can read everything. And therefore, what I largely will tell you is that it's the job of the researchers to read the subject. They must be the repository for questions which are directly not applicable to the problem and the laws involved. Because the speakers have to spend a lot of time reading the specific case law in specific sections. Now, once you've identified what the applicable law is, and you've done a reading, both general reading and the specific reading, comes the aspect of applying that law, which is everything, which is the final thing that you are expected to do as a counsel, whether you're a moot court participant or you're a lawyer later. How do you apply that law? You see, a lot of ideas of how to apply the law is in the judgments itself. Very few problems come on very novel points where there are no literature at all. There are no judgments. There will always be some kind of writings available on those points. And a lot of that analysis comes from there. I have been very happy when I went to a public international law, Moot, and some of those laws were absolutely open-ended. It allowed you to have a strong grasp of your principles, be the core basis on which you could answer some questions. It really did not come from any literature which was already spoken about. And that's a lot of fun to do. But to be able to do that, there's a lot of significance for you to analyze that applicable law. And now, how do you analyze that applicable law? It's very difficult to communicate to you how do you do analysis, because everybody has their own method of analysis. And I will not be delving into methods of analysis today, or maybe in this entire workshop. But what I will emphasize and tell you is that analysis is not a single-minded affair. For a good, proper, rounded analysis, there has to be some kind of agreement and a lot of disagreement with other minds. So it's very important that you debate, you discuss. Please fight with your moot court participants, with your co-participants, but only on the law. Don't fight with them otherwise. There is always a lot of stories of politics and teams not getting along, which is fine. I'm sure everybody will learn from their experience. But it is very important that you must have some kind of a healthy understanding with your team, where disagreements on legal points are also encouraged. Because when you are going to finally argue the competition, look, all your ego will be punctured if you are asked a question to analyze a particular proposition which you've not thought of before. And therefore, it's very important that you discuss, you debate, you disagree. I saw with my personal experiences that a lot of times I was very strong on my view on certain points. नहीं, ये ऐसे ही argue होना है. इसको argue करने का और कोई तरीका नहीं है. And subsequently, later, I have seen that what my co-participant was telling me, said, maybe I was not being able to understand, मुझे समझ ही नहीं आ रही थी, that ये क्यों ऐसे बोल रहा है. Maybe when you argue this point, when you go to the second sub-issue, that point is going to trouble me somewhere. And the drafter of the moot court problem has created such a nuisance that one issue is conflicting with the second. So I can't take this line of submission. Very important कि मैं हर तरह से हर view से इस चीज को देखूं. So it's very important that you have some kind of meeting of minds. The next question is, what extent of research is required to be done? I think that I've already answered to you. The extent of research is obviously as much as possible. But there is a difference between reading the subject itself and doing specific research on specific points. And it is impossible to do all of it. So it's encouraged that speakers spend a lot more time doing specific research and researchers spend a lot more time doing general research. Now, before we take a break, and I'll be very happy to answer questions that come my way, something which is very important is case citations and compilations. Because this is not what you learn as a moot court participant. This is something you're learning for life. Whether you're going to get into academics, you're going to get into the judiciary, you're going to be a lawyer, you're going to be a practicing lawyer, you're going to be an in-house lawyer, it becomes, it is inescapable to deal with judgments, case compilations. And it's very important to learn case compilations. Just the way you are going to make a list of applicable laws, you're obviously going to make a list of applicable case laws. And I don't have to tell you that's normal. Students do that anyways. It is very important that when you're reading judgments, say, you're reading a particular point in a book, and there is a footnote which is of great use. You must write it down. And you must always verify the footnote. You must always open the original text of the case and see, does it really say that? A lot of times what you read in a single line in a commentary and look at a footnote can be very misleading. So it's very important that you fact check every case law. Once you fact check and you look at all the legal points on the case laws, you realize that not every case law is wholesome. In some case laws, only a paragraph is important to you. Only half a line is important to you. Be very sure that you know what's the difference between ratio decidendi and obiter dicta. And I'm not going to explain that because I'm sure a lot of you must have foundation on this. A judgment is applicable only when it is fully applicable. And when it is not fully applicable and you're taking a specific line or a point, it must apply in context. If it doesn't apply in context, a single line here and a single line there is a trap. You may cite it, somebody may look at that case citation, take out some other point and tell you, no, but it says this, it's in another context. So don't fall for the immediate relief. Sometimes when you're researching a moot court problem, एक line मिल जाता है commentary book में and we are very happy. यार ये line तो बड़ा useful है. Or you read a judgment and you say one paragraph, oh, this one paragraph is very important. You see, that is not how it works. You need to know that a case must be fully applicable to that given situation. And if it is not, only if a few line is applicable, you must know the context to either differentiate it or apply it. Also, when you are doing case compilations and when you start finding case laws which is wholesome to you, please take printout of those case laws. I understand now we are moving to a digital world where we are very conversant working on iPads and laptops. But for moot courts, it's very important for a lot of you to have a visual memory of what you are dealing with, because you deal with a lot of content in a very short span of time. And if you're going to read everything from a digital medium, you don't really have a visualization of that content. Sometimes I know that, if there is a thick judgment of 100 pages, I have to maybe, flip half the book to get to that particular page. That kind of visualization you can never get on a digital medium. So I'm also not recommending that you run your printer dry of ink by printing everything. That's also not possible. But judgments which are wholesomely applicable, kindly take printouts. Please feel free to scribble on it, scribble, scratch, dirty it, because that's how you have a visual feel of a case law. What you make for case compilations, which you give to the bench, look, that's an aesthetic exercise that you do towards the end. And that again, I'll speak about researcher roles. That's what the researcher is supposed to do. So in the first half hour, we've discussed about moot court problems, how to read it, how to analyze it, how to memorize it. We have spoken how to identify the law, read the applicable law, what extent of research we are going to do. And we have sort of had a brief understanding of how do we deal with case citations and compilations. Let's take a break at this time, and I'll be very happy to answer questions, because I'm sure each of us have our own experiences. कुछ बड़े बुरे experiences भी होते हैं इस issues पे. So I'll be very happy if I can answer some questions here.
Students are requested to ask their questions if they have any. You can write down in chat, or maybe you can ask pertinent to the topic. Anyone of you who has some experience of mooting, who incurred or encountered some kind of problems in that regard, if you want to ask any clarification, you can ask.
You can even share your experience. I understand some of it need not necessarily be questions.
So Animesh, in the meantime, students will ask, okay, so we have got a question, how to make a specific notes while researching, what to keep in mind while researching.
Very, very, very important question, but I have no answer because it's very, very specific to what you are researching. And that's the whole fun of researching. Whenever you pick up a proposition and you start researching, you yourself start getting answers on sub points, points which look in favor, points which don't look in favor. So you must have a method of dealing through that. For example, I have always been a very poor note maker. Even till date, I was very poor with it. Before I entered law school, I was very poor in law school, and I've been very poor thereafter. And therefore, I've had a mechanism where I spend time while mooting. I would spend time thinking about specific points. Okay, this is the point. What questions can come my way in this? What could be the answer? Maybe, when I read that case law, it says this case law, it says that. So it worked for me to keep a lot of it in my memory. But I can tell you that it can be, if that is not your natural way of dealing with it, I understand that it can be very overwhelming when you've gone for the competition. One of my co-speakers was very meticulous. He liked writing notes. He would make very meticulous, segregated notes, which were at different places. And that used to work marvelously too. If you would discuss something, he would quickly flip open his notebook, go to a particular part on the notebook and say, look, this is what I've thought about it. So it's very important that you must have some kind of note making. But how you do it is entirely, it's specific to every person.
Okay, so my question to you, Animesh, is that whatever you say, that analyze the problem, take read one day, then leave it for 2-3 days, and devote this much time. So it will be applicable when you have sufficient time. Means you are going for big moods and you have 3-4 months. Like sometimes the problem is we get the information of some mood at a very short notice. So we have only 1 week or so that we have to upload it. So how the students can prepare, suppose for the local, of course, problems, local mood competitions. So can you advise them how to go for that?
The good thing about local problems or problems which are to be prepared in a week or prepared in 2 weeks is that they largely revolve around 1 or 2 points. And the facts are also not so rich. So when I say that, you're going to read it once, twice, thrice, there are many problems which are to be prepared over 4 months' time. But when you're preparing something which is over 1 week's time, I think it applies for the mood problem, it applies. Every day you must read it 2-3 times. Because how you visually grasp the mood problem is really not how many times you've read it. It really means how many times effectively you've given sight to it. And if you've given effective sight in 4 days also, it could be very helpful. So I remember I could share my experience. Perhaps the first moot court that I went to was Commonwealth. And we had only 2 weeks to prepare, and that coincided with our exams. So of those 2 weeks, 1 week was that. And this is when I was fresh into second year. I had no background in public international law. So it was not only a case of understanding a problem, but understanding public international law, which was very difficult. And not every law school is very rich with resources. And my law school at the given point was not very rich in online resources. Therefore, whatever one could read, one had to go to ISIL to read that. So I remember it was very challenging to do that in a short period of time. But like I said, moot court is beyond winning and losing. Today, if I get a case at the nth hour, I get some brief which is today and it has to be argued tomorrow. I have a very short timeline. I'm not going to say ये नहीं हो सकता है. Mood problem करने में 3 महीने लगते हैं. Case prepare करने में मेरे को 2 दिन लगते हैं. As a lawyer, you will always be challenged to work on deadlines. So if we are dealing with short deadlines like that, it helps us in the longer run.
Right. Yes, it will be very helpful. Because sometimes we encounter this kind of questions that the time is very less and students, they feel very, tense at how to prepare that. Okay, another question has come. Sir, what are the basics to keep in mind to make a memorial of the problem and keeping technical things as well in mind? Example like footnote, etc.
Yeah. So I think that is for another session.
Yeah.
We are doing 2 sessions on memorials, and let's discuss it there.
Yes. Yes. So please let me know how to cast out irrelevant parts of the mood problem. When I
Yes,
okay, when
that's
I did the
I'm
mood
reading. Yes.
problems, yeah, I got yes.
Yeah, that's a good question, Priyanka. You see, that's exactly why I'm saying that you must write down uh, numbers against every line on the problem. And the effort is not to weed what are irrelevant portions out. The effort is largely to pick up the relevant portions. When you pick up the relevant portion, your mind automatically deletes what is not relevant. You see, the mind is a very curious instrument by itself. If you are traveling, to college and back, you will see so many numbers. You will see car numbers, car plate numbers. You'll see different human faces. You'll see the next day you don't remember all of it, and that's because when we sleep, our brain analyzes what is relevant information and it automatically deletes that information from our mind. And that's how this whole system of mood problem reading works. If you are reading a particular line over and over again and thinking about it, your mind automatically grasps the relevance of it. And by the time you go for the competition, it gets ingrained in your mind, those kind of facts. Such that, today I remember specific places where specific facts were there of my mood court problems, which I did back in 2003, 2004 also. And such is the imprint that you have when you're reading something over and over again. So largely, do not make an effort to weed anything out. Make an effort to see what is relevant.
Yeah. Okay. So another question has come. Can we assume some details about facts? Okay. Sanjeevni,
Yes,
kindly you go through the problem.
It's very close to my heart. The question which Neha has posed there. You see, a drafter, like when I was a mooter, I would always imagine that anybody who is drafting the problem, there is a human mind there. And the human mind is thinking something. Why is it that that particular fact the human mind has missed? Or is it that deliberately that fact has been kept away? Specifically, when you read case laws, you realize, oh, this judgment has been decided in this favor. But these specific facts, while they are there in the case citation, it's not there in my mood problem. And a lot of it is done, one, to make it more balanced, and a lot of it is done to leave it to your imagination. But what I will say that with a word of caution. Don't adventure into facts which are not there. There can be a necessary inference of a fact which is missing, and you could know why that fact is missing. Therefore, you can make an argument to say that, look, there is no fact which says so, and therefore it will be unfair to say that there is a fact like that. Or sometimes you could put 2 and 2 together and say the fact that this and this has happened, while there is no specific line which says that, the necessary inference is so much. And you win a lot of points if you are able to do a convincing analysis of missing facts on a problem. For example, for somebody like me, if a mooter has done a thorough analysis and has been able to take out some aspect of the intent of the fact of the problem, I'm very impressed.
Yeah, Animesh, someone
Yes,
wants
ma'am.
to ask question. I think so. Arvind Rao, if you want to ask question, you can unmute yourself and put question to the speaker.
Sir, this is open, and I would like to ask a question. Just now, like you have said that when we go to the mood competition, like we will prepare everything, like page numbering or line numbering and everything. And when we go for the first time, like some people get the time standard, they'll mess up everything, they'll forget everything. And in those situations, so how do we handle the situation, particularly in those cases? Like, we'll
No,
be
that's
having
that's that's a very good question, and I'll quickly answer that.
yes,
You see, how good you are on the day depends a lot of how you've prepared for the problem. And while I understand today we have made a beginning, by the end of the workshop, I hope I'm able to answer very specific points. And I will answer those specific points in one of the sessions, which is perhaps the penultimate session that we are going to have in the workshop. What do you do in competition day? It's very important for you to be in some kind of relaxed mindset 10 minutes before your round begins. And you are able to do that only if you've done your preparation properly And secondly, you have the confidence to switch off for 10 minutes before the competition. So how you're going to do that, we'll discuss that in a separate session. But yes, very important.
Thank you, sir.
Kindly ask the questions which is related to the today's topic. Thank you.
Which is fine, ma'am. I think let them ask whatever question comes to their mind. I'm making a mental note of some of these questions. Okay, there's one question from Charu here, I see. Never add facts on your own, like I'm saying. I mean, it can be, if a fact has been kept absent, I'm sure 99.9% of the times, the drafter of the Moot problem has thought of something to keep that point absent. And you see, it is only in very few problems and at very few places can you really make an argument on missing facts. And like I said, it really impresses me. But you see, there is a high burden. If you are doing it just for showing off, if you're just, trying to show that I'm different, it doesn't work like that. You must have a very sound understanding of why that fact is missing and what is your legal argument to support that fact. So while I'm saying that dealing with missing facts is great, I'm saying with a very strong word of caution. Don't do it as a matter of routine. I'll give you an example. One of the Moot courts I'd gone to, and I think I was referring to it in the first session, which was sort of on a celebrity driving on the road and driving over pedestrians. And in the fact sheet, there was no mention of what the weather conditions were. And one of the participants said, look, it says that the location of the particular accident was Delhi, and I've taken the report of that day. It was a very foggy day. And therefore, what led to the accident was fog, and there was no deliberate intent. And we had a ball of a time trying to shred into him. Because we said that while he's gotten the report, his report doesn't say which location in Delhi was this. Which location is the accident? Maybe Lutyens Delhi sees more fog than some of the more densely populated places of Delhi. What time was the fog report taken? The Moot problem is absolutely absent on what time was the accident. It just says it happened late in the evening. So you see, when you adventure like that, it can backfire terribly. So be very clear when you're adventuring on such propositions. Should we then move on? Yes, sorry, ma'am. Yes.
Yeah, I think we can take up some more questions in the next session later on. So you can just have your presentation and then we'll take some more questions towards the end.
Sure, ma'am. Now, the next point on the table is strategy, but I'll skip that and I'll come to preparing likely questions and answers. For those of you who were there with us on the first session also, I explained an example where I'd won for this particular competition and the rival speaker had made a list of questions and answers. And therefore, every time a question was put to her, she not only knew the answer, she had written that answer in a sheet, she had memorized those answers. So not only were the answers correct, they were perfectly drafted as well. And there was something great to learn from there. I realized that if you are going to prepare likely questions and answers, that is going to help you in every way. My view originally was that you shouldn't do that because there has to be some kind of freshness to your arguments when you go there. But I think today I can say that that's a view I think is not correct. The view that you make that meticulous preparation of writing down questions and answers can really help you. It helps you in a very unconscious manner also. Sometimes when you're asked a question which is not on the list of likely questions that you've written, your brain automatically knows that you've not thought of that. So you listen to it more carefully. If you have written down a question and a question has come to you, it's also very important that you patiently hear the question down. And that's a mistake which was pointed out to me in one of the competitions. So some of you may have interacted with Mr. Rajshekhar Rao, who's doing very well at the bar. And he was my Moot court judge. And when the score sheet came out, I was very excited to know that he had marked me very handsomely on the score sheet. So I ran to him and I said, what kind of feedback would you like to give to my presentation? And I wasn't really asking him for feedback. I was really looking for compliments. The fact that he's given me such good scores, he'll have something nice to say to me. And maybe that's all that I wanted to hear. He looked at me and he said that, you know, every time I was asking a question, you had that smirk on your mind. ठीक है, खत्म कर ले, इसका तो आंसर मेरे को आता है. And he said that, you know, I saw you as such a cocky counsel. And I think, you know, that is one lesson which I learned right there. It was a hard lesson, and I think a very important lesson to learn. When you have prepared likely questions and answers, you must respect the question that comes to you. Whether you've heard that question before or you've not heard that question before. A lot of times when we know an answer, we become very excited to answer it. And if you look like this enthu cutlet who's always jumping to answer it, मेरे को पता है, I'm telling you, the judge will double up his efforts to tear into you. He will then think, oh, okay, इसने सोचा हुआ है likely questions. Let me now start thinking of a very tangential or a very novel argument. Let me try to become very aggressive with him. Let me try to be very disagreeable with her. And let me just throw her or him off balance. तो ये भी बहुत important है कि जब हम लोग ये presentation अपना देते हैं, हम लोग को ऐसा नहीं होना है that we invite trouble for ourselves, that we are so cocky कि जज कहता है अच्छा ये इतना स्मार्ट बन रहा है, ठीक है चलो अभी मैं देखता हूँ इसको और कैसे डिफिकल्ट क्वेश्चन पूछ सकते हैं. So that is also very important to deal with. You see, you understand a lot goes on while you are making presentation on competition day. You are worried कि आपके सारे नोट्स आपके पास हैं कि नहीं, सारा केस कंपाइलेशन है कि नहीं, वो मटेरियल कहाँ रखा हुआ है, ओपोनेंट टीम कौन से लॉ स्कूल से आई हुई है, अरे ये तो बड़े वेल प्रिपेयर्ड लग रहा है, इनके पास बड़ी सारी कंपाइलेशन है. You sometimes see a judge whom you would have seen in court before and think अरे ये तो बड़ा ही aggressive type का आदमी है, ये तो बहुत क्वेश्चन पूछने वाला है. Sometimes you look at a sleepy judge and you think, oh, he's not asking me any questions, so he's very nice, so let me just look at him and answer my questions, so next time there will be no follow-up questions. And the other two judge thinks अरे ये तो बड़ा smart है ये, he's not addressing all three of us, he's addressing only one person. So it's very important to know how to deal with answers separately from questions. It's one thing that you've been able to think of all the questions, write it down, draft it down from beforehand, let the judge finish the question. It is very important that you need to know how to answer also. And the answer must happen like this. I think the thumb rule is that when you are asked a question, you must wait for a judge to finish the question. Because sometimes judges also like their own voice and they don't finish the question. They'll start giving you their own comment. अरे ऐसा है तो फिर ऐसा है तो फिर judgment में ऐसा है. At the end, there is no question sometimes. Sometimes they ask a question and then they start ranting on a comment. Or sometimes they rant on a comment and the question is somewhere at the bottom or in the middle. So it's very important that a person listens to it calmly. बहुत आराम से बहुत जरूरी है कि जो जज पूछ रहा है उसको सुने, ताकि क्या right question है उसमें उसको जानना बहुत जरूरी है. Once you know that, there is no point for answering a question before the question mark on the question. So let it finish. You are also allowed to take a deep breath. You see, कई बार क्या होता है, question आता है, you're very worked up. It really helps that the person finishes the question and you as a speaker take a step back, take a breath, and then you say, in my opinion, the answer to the question has 3 points. You see, this is like an opening statement. In my opinion, the answer to the question has 3 points, 2 points. I am not thinking at this point of time. I'm actually thinking of my answer. It's what you call a takiya kalam. And I think, as mooters grow, everybody learns, everybody has their own takiya kalams. You must have that. This is what I call when you buy time from the court. You are saying something, so you're engaging with the judge, but your mind is not engaging with the judge. Your mind is actually thinking, अच्छा इसका क्या answer था? इसमें कौन सा case law था? Oh, I've read it. For you to do it, you are not going to do it like this. अरे क्या point था? मैं सोच रहा हूँ. अरे कहाँ लिखा था? कहाँ? That's not the kind of expression you can give while you're presenting. But you are going to go through those emotions. And the way you go through those emotions is like this. Take a deep breath and say, that's a fair question, Your Lordships. The point on this question must be answered. I think it can be answered in 3 points. And you see, this is the time that you buy to find your answer. Also know that the human mind usually doesn't like to register more than 3 points. So even if you're watching a news debate, see, anybody says, I have 5 points on it, you automatically switch off. 5 points किसी को सुनने का मन नहीं करता है. So 3 is the maximum time limit. Even if there are 5 points to say, my suggestion to you is never say you have more than 3 points to say. You don't also have to identify how many points you are saying. You could just then say, the answer to that, your lordships, would be, and then you say it. Say if you have asked a very tricky question and the answer to it you don't know, या आपको याद नहीं आ रहा है वो answer, say it as slowly as you can. That affords you more and more time to think, visualize. And if you don't, if you train yourself not to appear nervous, you see it appears very well visually. It seems कि आप कितना सोच समझ के बड़ा गंभीर आंसर दे रहे हो. So it's something which I have seen of senior lawyers in court also, that a lot of time when questions are put to them, they are very patient. They hear it out. And then when they give the answer, they give it very slowly and very calmly with some context. And when you go for moot courts, you realize what the speaker is doing. He's only buying time to think. He's only trying to see the judge. Where is the judge? Is he continuing to be aggressive with me? Does he really want to ask, hear an answer to this question, or he has another follow-up question? So that's a very good way of dealing with answers. It is also very important to know that there is no point for giving extempore answers. अगर किसी ने आपसे question पूछा है और उसका आपको right in your memory answer नहीं पता है, there is no harm in asking for some time. To say that, your lordships, to be able to answer that question, I may have to look at my memorial if your lordships would allow me, if I could do that. If you make a polite request, nobody will say no. Flip out your memorial or flip out your notebook, come to the relevant point, look at it, analyze it, and you give the answer. The idea is that there should be no silent pauses. It shouldn't be somebody has asked you a question and then you're like, that shouldn't be there. That means that you are lost. That means that the judge knows you are nervous now. You must be able to fill this silent gap with some takiya kalam, which I have already discussed. How do you deal with questions which are very aggressive? This is one question, second question, third question, fourth question, fifth question. And here maybe I have another story to share. This was my very first moot court. It was an internal moot court. And I was used to debating in school. So I came from a background of debating. And I said in the first session that debating, you need to unlearn many things to become a good mooter if you're a debater. It's not like, अरे अगर आप अच्छे debater हैं, तो आप अच्छे mooter बन ही जाएंगे. And I went for the first round. My first round went very well. When I went for the second round, the first round was judged by 4th years. The second round was to be judged by final years. When I went for the second round, the moment I entered the courtroom, one of the judges says, "Oh, acha, this is that guy. Okay. And the moment I began, they started firing questions at me. Judge 1 asked me a question, Judge 2 asked me a question, and Judge 3 asked me a question. Before I could answer, there was another round like that. And once that happened thrice, I was foolish enough to tell the judges to say, please stop. I have 12 questions. Let me answer these 12 questions first before I take any further questions from you. And then I answered those 12 questions meticulously. And after that, there was complete silence from the bench. They did not ask me a question. And I found myself on such hot ground because I just didn't know. They were not engaging with me. They were looking into their memorial. That someone was looking out of the window. They deliberately did not make any eye contact with me. And that was very difficult. And then it was explained to me that, look, if a judge takes a spoon and tells you it's a spoon, you don't say, no, idiot, it's not a spoon, it's a fork. That's not how you present the answer. You present the answer by saying that I understand that your lordships have put the proposition to me that this fork is a spoon. But your lordships, let me explain why this fork is not a spoon. Let me be able to explain to you why this is a spoon. And it's very important for you to be able to draft your answer, even if there is a severe disagreement with a bench. So if a bench is badgering you and asking you a lot of questions, just quiet down. Maybe what you could do is start writing the questions. Then the judge knows that, oh, you are writing the questions. They would immediately try to slow down to give you the time to maybe write the questions. And then, you will say, okay, your lordships, I have been able to note 4. I humbly apologize if I have missed any question. Your lordships will appreciate there was a barrage of questions, but I'll be very happy to assist your lordships on these questions. Let me answer this one by one. Question 1 that was put to me was this, and the answer is this. So you see, even if a barrage of questions is being put to you, you can deal with it by giving your answer very calmly. Sometimes a judge asks you a question which is very irrelevant. It's not even on the fact of the problem. Some judge who's not even, he's traveling to the day of the competition, gaadi mein usne fatafat pad liya moot court problem, he has no analysis, he's not done the same kind of in-depth study as you have done. asks you a very random question. You're not going to give him an expression. What? It's not there. This is not the answer. What question is this? It's very important that you respect the judge like that, to say, Your Lordship, that question seems pertinent. But let me say, Your Lordship, maybe for these reasons, that question is not relevant to be answered for me to make my submission. I'm actually making my submission on an entire different structure of arguments. So when you're dealing with questions and answers, it is very important that you know how to answer, not just the content of the answer. Very important. And we will deal with it briefly when we do the penultimate session on what do you do on competition day. But largely the idea is try to identify likely questions. So when questions are asked, you are familiar with the questions. And if a new question is being asked, your mind automatically knows it's a fresh question. How do you deal with answers? Please let the judge finish the question and please figure out what is a way of presenting an answer. It helped me to visualize these situations from beforehand, to rehearse, an evening before the competition. While you're traveling to the competition, you have music in your ears, your eyes are shut, you're thinking, अच्छा, अगर मेरे से कोई aggressive question पूछेगा, तो मैं इसको ऐसे deal करूंगा. अगर कोई मेरे से silent question पूछेगा, तो मैं इसको ऐसे deal करूंगी. It really helps to visualize some of these situations. So when the situation comes to you, you already have some kind of understanding how you're going to deal with a question like that. Now, the next point I want to speak about is clarifications to the moot problem. You see, while it seems very insignificant, I see a lot of teams faltering, and I can't understand why, frankly. There are a lot of participants who falter in this. And I think the reason why that happens, and this is my guess, is because we do a lot of preparation at the nth hour. We have just so much to juggle with. Memorial banana hai, arguments banana hai, case laws hai ki nahi, case citation hai ki nahi, मेरे teammate से भी झगड़ा चल रहा है, मेरा time भी ठीक नहीं चल रहा है, मेरे को college में time भी नहीं मिल रहा है, कोई assignment भी देना है, exam भी देना है. A lot is going on in your life, and this is what I'm imagining. I'm sure a lot more can be going in your life. At the nth hour, when you have so many things, one thing which you try to push at the background are clarifications that come to a moot court problem. Sometimes clarifications turn everything, and sometimes the clarifications really have nothing. But it is very important that you know all the clarifications well. And if those clarifications have changed some preparation in some way, very important. If a participant has not seen clarification, that is a sure shot reason to dock the participant points. So while it is very believable that, if you're dealing with it at the nth hour, you were probably junk dealing with that, but it's not something for which you are forgiven. So very important that you deal with clarifications properly. How to effectively prepare arguments from both sides. This is especially very difficult for first-time mooters. जब हम शुरू moot बनाते हैं, we read a problem, we sort of get a sense of it, and in many ways, we humans have a tendency to take one side over the other. And then we say, yeah, this is very lopsided in favor of the claimants. नहीं, ये respondents के लिए case है. नहीं, ये सब point जो है claimants के लिए. And कई बार ऐसा होता भी है. As a good drafter of a problem, I always feel that a problem must be made well. A good problem is a problem where the first issue, if it's more favorable to the claimant, then the second issue must be more favorable to the respondent. A whole problem overall should not be favorable to one side or the other. But you see, there is no fixed formula. You cannot measure it down to the decibel. You can't measure it down to the decimeter. For you to have a balanced problem, there will always be some kind of imbalance at some stages of the problem. And quite frankly, there's a lot of fun to argue an imbalanced argument also. And it's easier. Sometimes it's more difficult to argue a strong point. If you're arguing a strong point, you must not make a mistake. That's what the judge looks at. ये तो strong point है, ये claimant के लिए, claimant का counsel argue कर रहा है. He should not make a mistake. If the respondent counsel who is arguing a weak point, the judges say, नहीं, ये तो weak point है, ठीक है, even if he's not being able to give a clear answer, I appreciate इसमें तो clear answer है ही नहीं. So never get worried how you're dealing with a lopsided problem like that. And to effectively argue from both sides, I think there is a way to do it. And this is a painful way to do it. It's like mathematics. You can't rehearse maths in your head. You have to put down the hard yards of practicing over and over with pen and paper. How to effectively argue for both sides is something similar. Now, what I propose, and people are free to find their own way of dealing it. In almost every format, there are two speakers to a moot problem and one researcher. I say that one half of that time really depends on what kind of time you have on it. One speaker should start preparing from one side, and the other speaker should start preparing from the other side. I don't like this business where one speaker says issue 1 or 2 मैं बनाऊंगा दोनों साइड से और issue 3 और 4 तू बना लेना दोनों साइड से. How convenient. Same kind of research मिलेगा, काम छोटा हो जाएगा, हम दोनों का बन जाएगा. I'm telling you that's sure shot. If you are a mooter yourself, you know you are doing it. When you start judging moot courts, you will know that the person in front has done something like that. You will always try to trap him on that preparation methodology. And it's foolish. A good mooter is able to argue the entire moot problem. Issue 1, 2, 3, 4, 5, all of them. There cannot be a division ki do maine ne kiya hai aur do usne kiya hai. If you are a mooter like that, great. You will do well. You will make yourself happy. But I don't think you will survive through very tough semis and very tough quarters. If you are going to deal with tough quarters and semis, you must have the ability to argue all the issues yourself. And both speakers must have the ability to do that. And for that, one speaker should prepare the problem from one side, and the other speaker should prepare the problem from the other side. And thereafter, you will have arguments to say what argument sticks, what argument doesn't stick. And then you flip the role over. That way, you see, you are preparing 4 times than what you are doing otherwise. And if you are preparing one issue from both sides, your mind will always be prejudiced on how you began preparing that problem. अगर आपको शुरू में लगा कि ये क्लेमेंट साइड के ये केसेस बड़े स्ट्रांग हैं, आप रेस्पोंडेंट साइड उसको रिकंसाइल ही नहीं कर पाते हैं, और आप क्या करते हैं, एक डिफरेंट टाइप का आर्गुमेंट ढूंढने की कोशिश करते हैं रेस्पोंडेंट साइड से, which is entirely different, which is good. But you see, what you are doing in a sense is you are escaping finding answers to the strong points. Don't do that. It becomes very easy. And once you will become a moot court judge yourself, you will realize that these things will naturally come to you, and you will start querying mooters, and you will start finding them out. So to prepare effectively for both sides, very important that you have role play. Both speakers should prepare for both sides, invert roles, and you must know how to argue both cases from both sides. This also helps that when you are going for most competitions, you get 2 rounds of prelims. And in each round, you have to argue for one side. एक applicant side से argue करोगे, एक respondent side से argue करोगे. ये सबको करना पड़ता है. और ये सारे matchups होते हैं, toss-ups होते हैं. It is very important that when you take the podium for the applicant side, you know you are for the applicant side. And I'll tell you one thing which works. You see, if you are a lawyer और आपके पास client आता है, you cannot be divorced emotionally from the client. You will have some kind of feelings for the client's situation. And therefore, when you're arguing in court, even if the judge asks you a question, you remember, अच्छा वो client आया था, उसने बड़े painfully ये बात कहा था, उसको बहुत चोट पहुंची थी, that his brother took the entire family business from him and he ousted him from there. So he said it with a lot of hurt. You will remember. Why? Because you have some kind of emotional attachment to the facts. It helps if you have if you start developing some kind of emotional attachment with your moot problem. But I say it with caution, don't be emotional about it. I'm not asking you to be emotional, because the whole concept of being a lawyer, the whole large concept of being a lawyer for centuries together is somebody who can unemotionally and dispassionately present your point to court. So don't become foolish to say, oh, isne murder kiya hai, isko to main jail bhej ke rahunga. That's not what's going to happen in the competition. What you are supposed to know, why I'm saying that you must have some emotional connect to the facts, is that you never confuse whether you're arguing for the applicant or the respondent. In your mind, you can make a switch. Yes, now I'm arguing for the person who's committed the crime. Oh, now I'm like the public prosecutor. I'm arguing to get this criminal in jail. That's a mental switch you can do within that 10 minutes which I spoke before you begin your rounds. Okay? Access to resources. You see, in most law schools abroad, This is not even a point in discussion. But it's a great point of discussion for us in India. Different law schools have different resources, different capabilities. Some of them are still very traditional in terms of maintaining libraries. Some of them are very heavily dependent on online sources. Online sources have also become very good now. There are so many different online sources. If you're dealing with public international law, or if you're dealing with private international law, or you're going for comparative moot problems like Oxford Prize, you are dealing with so many different laws which are only available on online sources. We do not have a central library in India, which is sort of a very composite repository. Some advantage we have being in Delhi, because ILI is here, ISIL is there. Even the Delhi University Library in terms of the stocking of commentaries is excellent. But you see, there are pluses and minuses, whichever law school you are there. So you must beg, borrow, don't steal. Beg, borrow, and get access to resources however you want. Feel free to pester people you have interned with for access to some of resources. Feel free to pester your teachers who have taught you that particular subject to understand. Say it's a problem on criminal law. It really helps to get some kind of perspective on Code of Criminal Procedure. Sometimes when we study Code of Criminal Procedure as students, it's very difficult to learn procedure theoretically. It's something which you understand only when you see it in practice. So sometimes going to a teacher, going to a practitioner can be a lot of help. For example, CPC and CRPC. Practitioners know these tricks because they're trying it every day. Even teachers don't have the liberty of seeing how lawyers are dealing with different aspects of procedure every day. So beg, borrow, don't steal, but beg and borrow and try to get access to resources however which way you want to. Sometimes that also becomes critical when you're doing large moots. When you've got 4 months, 5 months, you see somebody who has access to all resources upfront gets a head start on you. So you must know that you have to put in more number of hours than somebody who comes from a law school which has access to a lot of these resources. Now, lastly, I'm going to deal about work management, time management, and team roles. I think in many ways it's the backbone of winning a moot court. If you get this right, it is the backbone of winning a moot court. And if you get everything else right and this wrong, no matter how good a mooter you are, no matter how well prepared you are, what kind of grasp of knowledge you have, if your work management, and team roles suffer, it's very difficult to pull a team. If one speaker is very good and the second speaker is not very good, it's very difficult. And often there are heartbreaking moments when as a judge, you see that there are 4 speakers, but the best speaker is not going to win because his co-speaker was not good enough, or that their tune was off. उनके आपस की coordination इतनी off थी that you see, as a team, though that speaker is the best, but that team will go through because as a team, that team was poor. And it's very painful. You feel for that one participant who's done very well. He deserves to win. But you see, this gives you no consolation. Oh, I was the best speaker of all the 4, but मेरी team जीती नहीं. That consolation is nothing. So it's very important that you build your team upfront. Now I understand that this will happen where you can't always find the best moot court co-mooters. Sometimes you don't get a choice of your favorite co-mooter. Sometimes you really don't get along with your co-mooter. Sometimes your working styles are very different. Sometimes your thinking styles are very different. That kind of differences are very common. So if you are a smart mooter, you will know that these differences exist. You're not going to find, your job is not to look for similarities in your co-mooter. And it's very important later when you're dealing with lawyers, when you're working in a law firm or a chamber and you're dealing with different colleagues, bosses, seniors, intermediate level people. People have different ways of working. They have different hours of working. They have different styles of working. So you see, this is a great primer in law school that you learn to deal with different minds, different behaviors, different personalities. You learn how to deal with these issues. So moot court provides you with an excellent platform to learn some of these aspects of human behavior, which will stand you in great stead later in life. Time management. You see, in time management, what are the things that you need to manage your time for? If your mood code is of 15 days, you aren't doing 15 into 24 hours or 15 into all the waking hours only to do mood code work. Especially if your problem is for 4 months, you are not going to be working on the mood problem all of these 4 months. So it's very important for you to know what are you managing in terms of time. Mood problem is one aspect. Specific legal points are one aspect. General legal points are one aspect. Strategy is another aspect. Question and answers is another aspect. Procedural laws is another aspect. So a good mooter would make out different categories of work that you are going to do, because otherwise it will be very overwhelming. Once you categorize different things, then you are able to map out that इसमें से कौन सी चीजें बहुत important है और इनसे कौन सी चीजों को मैं कब करूंगा. For example, if you are a person who likes to work early in the morning, maybe the first thing you should do while you are working on a live Moot, every morning when you wake up, read the problem once or read the relevant paragraphs once. Or if you're a very evening person, you know, at whatever time your mind is very receptive to analyze, read the Moot problem. At a time where, you know, especially when you're dealing with case citations, it's very energetic centric work. To see the citation, to see a judgment. Judgments can be of, so it's, in fact, in the morning, I saw a very funny meme. For those of you who've gone for public international law may relate. It said that if you have a case compilation which has the Nicaragua judgment, the case compilation is this thick. And if the case compilation doesn't have the Nicaragua judgment, the compilation is this thin. And anybody who's gone for a public international law moot, that's so hard-hitting because you realize that the Nicaragua moot, for example, I remember as a law student, I didn't have the money to print out the Nicaragua judgment or get it Xeroxed. It was that big. And I had to then, you know, work on a system to say, yeah, I can't afford to print the Nicaragua judgment. And even if I print it, I'm not going to read a judgment which is in volumes. What am I going to get out of it? But it is such a critical judgment with such important aspects of public international law defined, and development has been made criticizing the Nicaragua case and supporting the Nicaragua case subsequently. Very important to know something like that. So I realize that it is very important. I realize upfront कि Nicaragua case को तो मैं पढ़ नहीं पाऊंगा moot court के problem cover to cover. ये possible नहीं है. And how am I going to pick up a book which I have access only to in ISI? And in ISI also in those days, we were given access to commentaries, but we were not given access to journals as students who would go there. And only on special request, you know, those journals would be presented to you. So in that short span of time, where before the ISI library would close at 5:30 and our law school used to be till 3:34, by the time bus लेकर के हम पहुंचते थे ISI, वो 1 घंटा का विंडो होता था. I realized कि इस 1 घंटे के विंडो में मैं 1 महीने में निकरगुआ जजमेंट ही नहीं पढ़ पाऊंगा, बाकी का तो बात ही कुछ और है. So I realized that the only way I am going to be able to understand Nicaragua judgment is from somebody else's analysis of Nicaragua. So I started looking up articles. And so you see, when I'm talking of a time where Google was not such a strong search engine, we did not get a lot of that content there. To be able to then, you know, look at articles which had analyzed the Nicaragua judgment were very important. So it's very important that at the beginning I have an idea कि मेरे को कितना काम करना है और उस काम में कितना समय लगने वाला है. And in the beginning, you know, you can be very dreamy-eyed to say मैं सारे case law पढ़ लूंगा, सारा point बना लूंगा. ऐसा होता नहीं है. You need to be very focused that you have to reach a particular goal at some milestones. अगर 2 हफ्ते की मूट है तो 3 दिन में यहाँ पहुंचना है, 8 दिन में यहाँ पहुंचना है, 12 दिन में यहाँ पहुंचना है. अगर 4 महीने का मूट है तो ऐसा नहीं है कि 1 महीना मैं बिल्कुल मूट को भूल ही जाऊं कि सब चीज दिमाग से निकल जाए. हर 10-10 दिन पे कुछ होना है. अगर बीच में एग्जाम्स हैं और मैं 20-25 दिन एग्जाम्स में बिजी हूं, अगर मैं छोड़ देता हूं उसको कंप्लीटली मूट प्रॉब्लम को पढ़ना तो शायद वो मेरे दिमाग से निकल जाएगी. So to have some kind of framework is very important. Lastly, I see that I've eaten into a lot of the question time, but team role. सबसे ज्यादा मजा पता क्या आता है रिसर्चर से क्वेश्चन पूछने में, क्योंकि मैक्सिमम रिसर्चर जो है उसको वो बहुत कॉन्फिडेंट होता है कि मेरे से तो कोई क्वेश्चन नहीं पूछने वाला है, और अगर रिसर्चर की स्पीकर से बनती नहीं है तो रिसर्चर खुश भी होते रहता है. अच्छा हुआ इसको क्वेश्चन पूछ रहा है, वेरी गुड, ही इज बीइंग ग्रिल्ड. मैंने तो कहा ही था, ये तो बहुत अपने आप को स्मार्ट समझ रही थी, ये तो अपने आप को सोचता था कि इसको सब आता है, वेरी गुड. You see, that is very easy to note from a team. And when you will become mood judges, you will also note. And like you gossip, you will say, oh, इनकी जरूर कुछ गड़बड़ हुई होगी. And that's when, a lot of times, at least I a lot of time ask questions from researchers. Or if I ask a question and somebody is unable to answer, I say, ठीक है, let your researcher look it up. When you come back for rebuttal or sub-rebuttal, you let me know. Now, it's very important that a researcher knows what a researcher's role is. A researcher is not a non-speaking, unimportant member of the team, which is what mostly in India we think researchers do. Researcher's job is very critical because researcher ensures that there are no holes in the preparation. A speaker is so focused in preparing specific points in case laws. A speaker is so focused on the day of the competition कि यार मेरे से क्वेश्चन पूछेंगे, मैं जवाब दे पाऊंगा नहीं दे पाऊंगा, मेरे दिमाग में क्या है नहीं है, मेरा मटेरियल कहाँ है, कैसा है. A researcher has the best seat to be calm, to look at the speaker. And if a researcher is involved, उसको पता है कि कौन से ऐसे questions हैं जिसके आंसर मेरे स्पीकर को नहीं पता है. So if a judge has asked a question, researcher knows कि मेरे स्पीकर को आंसर पता नहीं है, अभी मेरा स्पीकर घुमा रहा है इसको, he will eventually have to come to. So that researcher can quickly make a chit and give it to the speaker. It is very important. A good wholesome team is made by researchers like that. Researchers' job is to know case compilations and materials at the back of their hand. If a particular question has been asked of a speaker and he's saying that in a case law it is there, the judge will say, where in the case law? Kis paragraph mein? A speaker is dealing with so much, वो suddenly कहता है पता नहीं वो कहाँ गया, compilation यहाँ है, वहाँ रखा है, किधर रखा है. It is the researcher's job to know that he takes it out in advance and gives it to the speaker so that the speaker has that. And to be able to have that coordination, you must have some kind of workability between speakers and researchers. So I always say that a good team is not only made by good speakers, two good speakers, a good team is made by good researchers. And especially when I am sitting on this other side and I'm judging moods, I see the difference when there are participative, active, and well-prepared researchers. So this is the presentation today. This is how I think, it helps you prepare for a problem. If there are some quick questions, I'll be very happy to take it.
Students, you can ask questions.
Yes. So I've seen Varsha's question. You see, this is again work management that you need to do. You need to see what kind of resources you have available at hand. If in case you have a library which is very hard copy centric, get Xerox of important case laws done up front. Prioritize that. Online resources, if it's not available, you will have to go to somebody's office or, get temporary access for some time. So you will get very limited access to online resources. So to be able to find the exact thing in online resources, you must be able to read your hard resources well. So जब आपको छोटा time limit मिलेगा online resource देखने का, you are not fishing in deep waters. You will know exactly what to look for. If say in case you have a very strong online resource and you don't have a very good offline resource, you see, the only disadvantage is getting prints. With an online resource, you can always print it and you have the hard copy of it. So if you have an access to a printer, that solves your problem. I hope that answers the question.
I think, ma'am, if students have any question, they can just send an email.
Yeah.
Instead of
So
holding him for longer.
I think the session is so, elaborative and clear that there are hardly any questions. They can send us. Yeah. They can, later on, they can ask the questions if they want to ask. Okay, so I think that the questions are not there. So I must say that the yes, so I must say that today's session is also very, very interesting. Like in the last session, Animesh has taken the importance of mooting, that why we should take the mooting and how it is helpful in our career. And now today he has taken the importance analyzing the mood problem. And I think he is very well said that reading rereading is the most important thing, because then every time when we read a problem we get to know some new facts of it. And I have this experience myself when I take jurisprudence as a subject of my teaching. Then every time when I read an article, every time I get to know something new which I did not know earlier. So this is a very good point, that the more you read the problem, the more you analyze it, the more you understand. Another point which he has taken, that not only the specific thing about that law which we straight away go, we have to read about the law journally. We should know what is the background, what is that law all about. And not only the that single line judgment will help, we have to read the whole judgment in order to find out that whether it is a relevant judgment or not. Like in one of the cases, a senior counsel was arguing a case, and the juniors prepared the case, and junior did the same thing. By reading the head note, they gave the judgment. And when the senior counsel did not look into that judgment in detail, and when he argued that, the judge asked that you are giving a citation against your case. So until and unless we read the full case, we do not know that whether it is relevant for us or not. Another thing which he has highlighted today is the time management. And this is very important, and I must be thankful to Animesh, because I also find different times for me that when my attention is the most. And definitely I will also try to use that particular time for my the most important things I do in writing. So that is another aspect. And lastly, the team management and how to run the team. And this is a very important skill, not only for mooting, but I think it is a life skill, because everywhere we cannot do anything alone. We need support of people, we require assistance from people, we need guidance from people. So teamwork is very, very important. And I personally appreciate the point which he has given, that one mooter should prepare from one side and another mooter should prepare from the another side. This point I like a lot, because when you start preparing from a side, that you give your best to that particular aspect. Otherwise you will be biased for that particular side which you are dealing for the first time. So when you are starting from different aspects, I think you will do your comprehensive research, and the best point you can have. This is what I summarize today's discussion. Thank you, Animesh, for sparing your time. And I think it is very, very interesting aspect. And it is useful not only for the Moot Court Society people who wants to participate in mooting, but I think it is very useful for the students of 5th semester who have to appear in examination on mooting. So I think if no other question is there, I should say thanks to Animesh. And thanks to Sanjeevni, Sushmita, and Daya for participating into this session. And thanks to all my dear participants. I hope that you are enjoying these sessions and you are getting so much knowledge and information from these sessions. So I hope that on Thursday, when we have a third session, definitely you will all join and will learn new things. Thank you, Animesh.
Thank you, ma'am. Thank you so much, everybody.
Thank you so much. Thank you.
Okay. Okay. Bye bye. Thanks, sir. Thanks. Bye, Animesh.